I did one in FCS.
Because I also don't think that the emphasis in this practice is Mercer. I think it's Alabama. So I think it's going to be hot.
I'm excited to see how these are.
That's what most of
Is he going to play?
It started because they said Daniel said that they don't, because we can't make it to a bowl game, so if he sits this game, then he can still play against Bama and not lose his
the other
red
option
shirt.
is,
Got it.
So he can still count as a red shirt.
Here, and we
So
can
he
set
still
up a
keeps
remote
4
from
years.
here to where you could
Exciting.
be here.
Because I think the motivation to beat Bama is now very high. Now
Well, I
that
didn't
they're
know, you know.
playoff
So I
ties
was
are
like,
dependent
that's
on.
why I was like, when do I need to?
And that's what always plays the best, is when we can destroy this.
As when we're spoilers.
Hurt their feelings really bad. Maybe we'll have a match.
The season will be redeemed.
But you're probably good.
You think we're gonna get the Tulane match?
I have no idea. I mean, there's so much going on right now.
I'm gonna look at one of your reports and give you. I'm gonna give you.
If he doesn't take you,
I'll incorporate
somebody
it.
might take
Well, I mean, I'll give you
I really wish we
suggestions.
could get Dillingham, but I don't think Dillingham would leave ASU.
Most people
Combine
combine
up.
them.
Yeah.
Again, I had to go with that one.
We all have room for.
Hey, Dr. Norton. It's nice to meet you. You want to go to California?
No, but I can see. So you're gonna be closer to Heckle?
That's right. High reimbursement, low psychiatry salaries. I am. How are you doing?
I've got 4 to 5
For seeing my old white man.
Easy with that.
Supposedly has Parkinson's. I don't think it's Parkinson's.
You're so skeptical, Dr.
Yes, sir.
When the man's refusing cinnamon and he walks better without it, I think he doesn't have Parkinson's.
And not, yeah, like, I would try to.
Every other week.
Oh, hey, you're here.
Once a month.
Okay, now that is the most interesting thing of all. Do you see what I see?
I signed for
There's a hat. A hat.
Yeah, what about who's in the house?
Yeah, we.
Oh, the hat.
contract.
That is the most interesting thing of all. The hat on top.
Very specifically.
I didn't know that he wore a hat like that.
I've seen, I think it's the only time I've had him. I've seen him in the wild.
No, you're putting him back on.
Don't try to take it off now.
All right, it's 11:01. I don't want to take Dr. Pickett's time away from his lecture because he's got a lot to share and it's going to be great. You want me to use a microphone? Okay. So, Finn Perkins, introducing Dr. Pickett. So, I'm going to read some of his bio and then I'll tell you a little bit about him and then he'll get going. So, he was raised in Raymond. Dr. Pickett, Dr. Pickett is a triple board certified physician. He is boarded in general psychiatry, forensic psychiatry, and emergency medicine. Raised in Raymond, got his bachelor's and master's at Mississippi College, then went to UMC for medical school, went to UMC for emergency medicine residency, then went to the UVA for psychiatry, and did his forensic psychiatry at UVA as well. He currently works as the medical director at North Mississippi State Hospital. I first met Pickett when I was a psychiatry resident at UMC as well. Dr. Pickett was an emergency medicine resident who spent more time with the psych residents than he did the ER residents and enjoyed talking about the psych patients way more than any of the procedures that he was doing. doing. And so he started hanging out with us and asking should he switch to psych residency. We all told him, finish your last year of E&M residency, you'll make more money than us and be able to moonlight. And now he has come to the dark side by being a forensic psychiatrist. He is going to be giving us a talk on insanity through the ages. I have seen parts of this previously, and it is a very good lecture. So thank you, and join me in welcoming Dr. Pickett.
Thank you. Thank you. Is this working? Yeah.
Yep.
Everybody. Okay, good. Working too good. Okay. What Dr. Perkins didn't tell you was he was actually my counselor. I'd go up to the psych lounge as an ER resident and lament to him, and he was like, "Man, you really should." So we spent many hours in the psych lounge, and I was contemplating switching, and I'm much happier as a psychiatrist. I still do some ER, but don't get me started on that, or this will ruin everything. Okay, so Dr. Perkins could actually give this lecture with me, and he did at the SPA. So if you were there, I'm sorry, but I felt like it's got a lot of good material. It is kind of dense. I kind of tried to throw everything I could in about insanity, and you're welcome to have this lecture. So you have a one-stop shop, essentially, for anything you might want to know or curious about. Okay, so let's see. My clicker.
This is a clicker too.
Oh, okay, let me try that one. Thank you. Okay, perfect. So there's a lot in here, as I said. We'll glaze through some things, but what is the insanity defense in general? It's a legal doctrine. Am I near the other one? Okay. It's a legal doctrine allowing for defendants to argue that they should not be held criminally responsible due to mental illness. It's based on the idea that punishment is only appropriate if a person has the capacity to understand and control their actions. It's not a medical diagnosis, but it's a legal standard. It is meant to protect the morally blameless. It distinguishes between mental illness and criminal intent, and it promotes justice while acknowledging mental incapacity. There's all kinds of statistics out there, but the ones that I thought were important, I found the insanity defense is rarely used, maybe 0.9 or approximately 1% of felony cases nationwide. And of that 1%, only 25% are successful. That equals around 1,500 defendants per year are found in GRI, and if they are successfully do an insanity defense, it's usually one in every 2,000 felony cases. It's usually raised in serious mental illnesses like schizophrenia or bipolar disorder. It's more commonly brought up by public defenders than private attorneys, especially in violent cases. And the recidivism rate of people who are found in GRI, as I'm sure some of our forensic people here, Dr. Gugliano, Dr. Perkins, I think Dr. Record may come, can tell you that it's no greater than the rearrest of people who are convicted criminals. So, if somebody's found in GRI by reason or not guilty by reason of insanity, what happens? Well, most of the time they're committed to a psychiatric institution, like here, Whitfield, our forensic unit, and sometimes they can be here for longer than their prison sentence would have been. It just depends. According to some sources I saw, it was somewhere between 3 and 7 years on average. And the defense is most often used in homicides, violent felonies, or sexual assaults with bodily injury. So just a little bit of background about forensic psychiatry and insanity. I really like it because it's this crossroads between human nature, involving motivation, intention, and the legal system with competency and accountability. If a crime happens, who's accountable for it? There's different decision makers like judges who determine questions of law and juries who determine questions of fact. And competency and sanity are typically questions of fact. Expert witnesses can often assist the decision maker, whether that's a jury or a judge, in this question. So it's not fancy. I made this little thing here, but it shows you have your decision maker, you have your expert witness, and we're going to go and try and help them talk about competency and accountability, which deals with insanity. did the person know what they were doing at that time? Should they be held accountable for their crimes? And so forensic psychiatry is a crossroads between the legal system and social issues of human nature and motivations and intentions, which I find interesting. So, talking about the decision makers, you have a jury, and you have a right to a jury trial. In criminal cases, that's your Sixth Amendment. In civil cases, federally, that's the Seventh Amendment. And it generally applies to serious offenses, not necessarily petty offenses that might have less than 6 months imprisonment. And the defendants can choose to waive their right to a jury trial or have a judge alone. That's called a bench trial. And interestingly, the Seventh Amendment of the Constitution restricts the judge's authority to overturn a jury's verdict on a factual issue. So let's enter some case law. Here is Ake v. Oklahoma. It's a landmark case, 1985. Glenn Burton Ake was arrested for murder. He exhibited bizarre behaviors and delusions. He was committed to the state hospital, put on Thorazine, and found competent to stand trial. He presented an insanity defense, and there was no expert testimony regarding Ake's mental state at the time of the offense. The jury convicted Ake and sentenced him to death. Ake argued that he should have had access to a psychiatrist's help in forming his insanity defense. So, why is this important? Well, it's important because the holding said that when an indigent person, many of us treat patients who may not be very affluent or have the means to hire a private psychiatrist, forensic psychiatrist, but these indigent individuals, when they show that insanity is likely going to be an issue, the 14th Amendment due process requires that the state provide access to psychiatric services, which many of our forensic professionals here do. And so in Ake, Oklahoma, the U.S. Supreme Court actually talked about the pivotal role that psychiatrists have come to play in criminal proceedings, and they were quoted as saying, to conduct a professional examination on issues relevant to the defense, help to determine whether the insanity defense is viable, to present testimony, and to assist preparing cross-examination for the state's witness. So forensic psychiatrists and psychiatrists in general, if you have an interest in forensics, can play a pivotal role in legal cases. So I've talked about witnesses. There's fact witnesses and expert witnesses. Fact witnesses state what they directly observed. They typically don't give opinions. They could be more seen as credible because they're not hired. You know, some people might be considered a hired gun, as sad as that is, as unethical as that is, but some people can be paid and so somebody who's a fact witness that's not getting a paycheck might be seen as more credible. An expert witness, this person has special knowledge on the subject matter. It's knowledge that's not normally possessed by the average person, and it's beyond just their direct observation. Experts may express opinions that have legal significance about the litigant's psychological harm, the causation of that, or the mental skills required to be competent to stand trial. This is just a few of the things. In practice, psychiatric expert witnesses may function to make the decision maker aware of the facts as well as their conclusions about the symptoms, causation, and prognosis. So I'm not going to belabor this, but it's very important that you know this, and if by the end of this lecture you can't draw this from memory, you're just never going to make it in forensics. I'm just kidding. The reason this is important is it just kind of shows you how complex the system is, and all of the shaded areas are different areas where a forensic psychiatrist or forensic psychologist, anybody in the forensic world could get involved in a criminal legal situation, and it continues. So it's very complex, and there's a lot of places where people are needed, and there's a lot of opportunity. So now now that we've got a little background, I want to talk about the history of insanity. Where did it come from? How did it evolve? I think that's important because, you need to know how we got to where we are. And so in the U.S., it's derived from English common law and includes medieval and even ancient theologies from Europe and the Middle East. In ancient history, theology, Adam and Eve exercised free will when they defied God. In philosophy, Aristotle talked about this. He formulated a concept of criminal responsibility as far back as the 4th century. And this distinguished between voluntary and involuntary acts with respect to blameworthiness or accountability. It's human nature. It goes back all the way to Aristotle. Even in the Roman Empire, there was, under the Justinian Code, insane offenders were treated with leniency because, quote, madness has no will. Here's a Latin term, I'm not going to try to say it, but it means an insane offender is punished sufficiently by his madness. So the fact that he's mad is punishment enough, was their thoughts in the Roman Empire. In the 13th century, there was a guy named Henry D. Bracton, and he laid the groundwork for the wild beast test, which we'll get to. And basically it said, an insane person is one who does not know what he's doing, is lacking in mind and reason, and is not far removed from the brutes. Like an animal, the insane are not capable of forming the requisite intent to commit a crime. In the 14th century, King Edward III recognized that insanity was a complete defense to a criminal charge. In the 15th century, juries began to acquit offenders based on insanity, with the earliest recorded insanity acquittal by a jury in England in 1505. 16th century, the maxim, another Latin phrase I'm not going to try.
I really need you to learn Latin.
If somebody wants to, go ahead, but I didn't want to embarrass myself anymore. So it says, it means an act does not make a person guilty unless they have a guilty mind. 17th century, there was a guy named Sir Matthew Hale, this strapping gentleman right here. And he said, he was an English jurist, and he said, who maintained that criminal responsibility required the will, which in turn required understanding. And he's quoted as saying, if these dementes are totally deprived of the use of reason, they cannot be guilty ordinarily of capital offenses, for they have not the use of understanding and act not as reasonable creatures, but their actions are in effect in the condition of brutes. 17th and 18th century, English jurists continued to emphasize the importance of the will and the intellect in criminal responsibility. Then we get to the 18th century. English law distinguished between misdeeds that are intentional, voluntary, and of one's free will from those that resulted from coercion or accident. And this is back based on Henry D. Braxton's groundwork from 13th century, which was 500 years before. Justice Tracy developed what's called the wild beast test. And it talks about, to be found insane, the defendant must be, quote, totally deprived of his understanding of memory and doth not know what he is doing, no more than an infant, a brute, or a wild beast. Now we get to the 19th century, the Hatfield trial in England, not to be confused with the Hatfield and McCoy's popular television show. Now, this led a more nuanced understanding of insanity beyond the extreme total wild beast criteria. And it introduced the concept of partial insanity. For example, a criminal act might be excused if it were the product of a delusion without reference to the awareness of the act's wrongfulness. It was a precursor to New Hampshire's and the District of Columbia's version of the product test. So now we're in 19th century, and Beck, he was a very important writer, and he wrote this, Elements of Medical Jurisprudence, and he supported what's called the right or wrong test for insanity. And it became generally accepted as the test for insanity across the United States, and it was eventually rephrased as good and evil, the good and evil test. So now we're in the middle of the 19th century, or 1843, and a guy named Daniel McNaughton comes along. He is a Scottish woodworker, and he delusionally believed that he was being persecuted by Sir Robert Peel, the Prime Minister of the UK, this gentleman right here. And so McNaughton shot and killed Peel's secretary, Mr. Edward Drummond. And so at trial, McNaughton was acquitted based on insanity. And so this made the people upset, and so the Queen Victoria, summoned a House of Lords in 1843, and together they developed the McNaughton Rule, which is actually what we use here in Mississippi, 200-something years later. So, and it says, every man is presumed to be sane. To establish a defense on the ground of insanity, it must be proved that at the time of committing the act, the party accused was laboring under such a defect of reason from disease of the mind as to not know the nature and quality of the act he was doing, or if he did know it, that he did not know what he was doing was wrong. And we'll get into what wrong means later. Is that morally wrong? Is that legally wrong? And this became the standard model for insanity. It was adopted into English law, most jurisdictions in the United States and the Commonwealth countries. And as of today, it remains the standard for the majority of U.S. states and the federal standard for the U.S. Then there comes along some other ideas where people thought, well, maybe McNaughton doesn't cover everything. Maybe we should consider some of these other things. Enter the irresistible impulse insanity standard. So the irresistible impulse test states that a person cannot be held liable for an act if the defect of mind made it impossible for them to control their impulse to commit this act. And it began to develop in the U.S. as a response to perceived limitations of McNaughton. It was used in some of these cases in Massachusetts, Commonwealth v. Rogers, Parsons v. State, Smith v. United States, and it gained some traction, often in some jurisdictions alongside McNaughton. So it would be like McNaughton plus the irresistible impulse. So one of the cases, Fisher v. United States, 1946, jury instructions explained, quote, wherein the mental illness overwhelmed or destroyed the defendant's will. In 1944, 17 states had adopted the irresistible impulse test for insanity, and some states, as I mentioned, combine the volitional impulse disjunctively, meaning with or, not and, with McNaughton. And so you can kind of see down here, the McNaughton is to know the nature, quality, or wrongfulness, and the volitional is they knew the nature, the quality, and the wrongfulness, but they could not control their actions. So there's a cognitive test, which is, did they know it? That's McNaughton. Volitional test is, could they control their behaviors? Could they control their impulses? Then there comes another rule. They say, well, McNaughton doesn't have it all. Irresistible impulse doesn't have it all. The Durham rule comes along, and not to be confused with Durham, North Carolina. Is Dr. Recor here? I know he went to Duke, so I wanted him. Anyways, the Durham rule, or the product test. This came from a landmark case, Durham v. United States. And Monty Durham, charged with breaking and entering. He had a history of antisocial behaviors. And this rule said that the act must be the product of mental disease or defect. Judge Bazelon and the U.S. Supreme Court of Appeals of D.C. redefined the insanity test in this criminal case. And they said a defendant was, quote, not criminally responsible if his unlawful act was the product of a mental disease or defect. This is much broader than, there he is. Your ears must have been ringing. This test is much broader than McNaughton. It does not focus on the cognitive ability to distinguish right or wrong. Instead, it relies heavily on the psychiatric testimony to determine if mental illness caused the criminal act. It was criticized for being vague, too broad, and overly reliant on psychiatric testimony, and it's largely been abandoned except for one state. I have it there. It's New Hampshire. They still use it. Did you see this, Dr. Recor? Durham, North Carolina? I said not to be confused with. Yeah. So, anyways. All right, so we've talked about the McNaughton, the irresistible impulse, the Durham test, or the product test. Now comes along the American Law Institute, or ALI, and they developed their model penal code in 1962. And it basically says, let's combine McNaughton, so the cognitive prong to know the nature and quality and or wrongfulness, with a volitional test, the impulse. Let's just put them together. Well, that was going along, and they say here, a person, this is how they worded it, a person is not responsible for criminal conduct if, due to mental disease or defect, they lack substantial capacity at the time of the conduct to either appreciate the criminality or wrongfulness. Depending on the state, some choose criminality, some use wrongfulness of their actions to conform their conduct to the law's requirement. So the first part of this is the cognitive part, McNaughton, but it used the looser term appreciate instead of to know. So it gives you a little bit of wiggle room there. And the second part is the volitional part, which addresses to control their actions or the irresistible impulse like we talked about earlier. So this was broader and more flexible. And states could choose between, did they want to use criminality, which is a legal term, or the word wrongfulness, which is a moral term. And we'll talk about that later. Just because something's morally wrong doesn't necessarily mean it's criminally wrong, and vice versa. In the 1970s, many courts adopted this model penal code insanity standard. And as far as the definitions, when you look at what is a mental disease or defect, it specifically excludes criminal, like repeated criminal acts or antisocial conduct. And substantial capacity is a less restrictive phase than the total inability, which allows for a wider range of use of this. Well, that was all good until John Hinckley tried to assassinate President Ronald Reagan. So in 1981, the model penal code test fell out of favor after a jury found Mr. John Hinckley Jr. not guilty by reason of insanity after he tried to attempt to assassinate President Ronald Reagan. And this verdict sparked public outrage. Many states and federal government then restricted the insanity defense by eliminating the volitional control component of the model penal code. So what is an irresistible impulse? We talked about it earlier. It's really hard to tell objectively if a person could not resist an impulse or chose not to resist an impulse. If a defendant's actions truly stem from an uncontrollable urge, secondary mental illness, or rather the impulse was simply not resisted. It's difficult to differentiate these two. So it made it pretty blurry, and there was no objective way, so a lot of states tossed it. They said, never mind, let's not combine the two. Let's go back to McNaughton because we don't even know, was this an impulse that he just simply chose not to resist, or was it truly irresistible? And so several states can use kind of a modified McNaughton if they want to keep that, but it is up to the states, and they do vary, and I'll show you that in a little bit. So then 1984 comes around, and there was the Insanity Defense Reform Act. And this, as they federally, they said they dropped the volitional prong, and it only included defendants who, quote, as a result of severe mental disease or defect, were unable to appreciate the nature or quality or wrongfulness of their acts. And it was considered kind of a modified model penal code, or ALI for short. And some states followed suit. And this reform emphasized that the mental disease had to be very severe. It also shifted the burden of proof to the defense. So before this, the prosecution had to show that the defendant was sane when they did what they did. This shifted the burden of proof to the defense, where the defense had to prove that the individual was insane when they did whatever the act is. It raised the standard of proof from a preponderance of the evidence, which is lower, to, I've been told, Dr. Reekler, correct me if I'm wrong, but 50% maybe, up to clear and convincing, which could be understood as 75%. I've got a pyramid here in a minute, I'll show you that, but some lawyers have told me, like, no, that's not correct. And I was like, okay, well, it makes sense to me, so I'm going to tell it to you too. It limited the scope of expert testimony. It banned, like, the ultimate opinion. So when we go in as an expert, we don't necessarily say, Your Honor, they are insane. I offer my opinion, and the decision maker, whether it's a jury or a judge, makes the final ultimate decision. So it limited our scope as experts, and it eliminated diminished capacity from federal federal courts, which I'll talk about in a little bit what that is. And it created this special verdict of not guilty by reason of insanity, or NGRI, which then triggers commitment proceedings, which we're all familiar with. Many of them come here. So some states just said, look, it's too complicated. Let's just give up on it. We don't want a insanity defense. Those include Idaho, Kansas, Montana, or Utah, and there's some others, actually. I got a map coming up. I don't suspect that there's many forensic psychiatrists or forensic psychologists there. I don't know, but there might be. So some of these cases, Clark v. Arizona, the Supreme Court held that due process does not require any single formulation of legal insanity, so the states can vary. In Delling v. Idaho, the U.S. Supreme Court declined to consider the constitutionality of abolishing the insanity defense, so they could have weighed in on it. They chose not to. And legal scholars have argued that abolishing the insanity defense violates due process of the 14th Amendment because it doesn't get into the mens rea or the guilty mind. It was Latin. So, as we talked about earlier, just some of these definitions can cause confusion. You know, what does the term wrongfulness mean? As you can see from this Venn diagram, some things are morally wrong, but they're not criminally wrong. Some things are criminally wrong, but they're not morally wrong, and some overlap. Wrong is, as I said earlier, a moral term, whereas criminal is a legal term. So, you know, a subjective wrong, the defendant's belief regarding whether the criminal act was wrong. An objective wrong is more so like society's belief of whether what they did was criminally or morally wrong. Some examples might be adultery. That might be morally wrong, but it's not criminally wrong. Or witnessing a child drowning but failing to jump in and intervene. That might be morally wrong, but it's not criminally wrong. The law doesn't force you to put yourself in danger. Interestingly, in Alaska, wasting big game meat is criminally wrong, but it's not necessarily morally wrong. Driving without a proper license. I haven't had a license for years, and yet I still drive. And that might be criminally wrong, but it's not morally wrong. So, to know or appreciate, that is the question. A literal reading of McNaughton leaves little room for application to most mentally ill individuals. Few defendants manifest a defect of reason such that they know neither the nature and quality of their act nor that it was wrong. But some courts have been more generous in their interpretations, removing the word know for a more strict, from a strict cognitive context and allowing more appreciation, which leaves more room. And so again, here in McNaughton, it says, every man is presumed to be sane. To establish a defense on the grounds of insanity, it must be proved that at the time of committing the act, the party accused was laboring under such a defect of reason from disease of the mind as to not know the nature and quality of the act he was doing, or if he did know, he did not know that what he was doing was wrong. So, the burdens of proof. A defendant is presumed innocent and sane. The insanity defense is an affirmative defense that now, since the reform in 1984, has shifted to the defense. So criminal law, the prosecution has the burden. This was back before the reform. The prosecution had the burden of proving that the person was sane. In this case, the defendant was sane. In 1895, in a federal case, if an insanity defense was raised, the prosecution had the burden of proving the defendant's sanity. After Hinckley's acquittal, that switched. And so let's talk about the burdens of proof. So as I was saying, beyond a reasonable doubt, whenever somebody is in a criminal trial, the prosecution has to prove beyond a reasonable doubt, which I conceptualized and was taught as maybe approximate 95% confidence. If you had to put a number to it, it just makes more sense to me that way. Around 95%. That's a high bar. Then for like terminating parental rights. You don't want to take somebody's kid away from them if you're not really, really certain. So maybe that doesn't have to be 95%, but 75%. Personal injury or negligence. You know, some of us as doctors might be a little worried, but that's a lower bar. That's like 50%. So search warrants, you know, they have probable cause, or traffic violations, just a reasonable suspicion. So, you know, if they want to do a traffic violation on you for running the red lights, like Dr. Perkins always does, you know, they don't need beyond a reasonable doubt. They can have reasonable suspicion. And we want it to be that low because we want police to have the freedom to do what they need to do. Well, insanity falls around this. It was the preponderance of evidence, and after the reform in 1984, it went up to kind of clear and convincing. So it's a higher bar, is what I'm trying to get at. So we've talked about McNaughton, we've talked about the impulse control, we've talked about Durham, the product test, we've talked about the model penal code. All this is great, but let's say I'm insane, and I want to defend myself in trial. But you say I'm insane, but I'm not insane, and I don't want the insanity defense. Can the courts impose it on you and say, you are insane and you have to do this? Well, enter Frendak v. United States, 1979. Paula Frendak, she murdered her coworker. There's a lot of jokes there I will stay away from. And murdered her coworker and was found competent to stand trial. But the court found her to appear psychotic and tried to impose the insanity defense on her. Well, it went to the Court of Appeals, 1979. And before this case, courts could impose the insanity defense on an unwilling defendant. But after Frendak, a trial judge, it was determined that a trial judge must first decide if the defendant waived their insanity intelligently and voluntarily. And that gets into informed consent, which I talked about at the mental health IDD if you were there. It's not in this one, but anyways. So jurisprudence regarding involuntary imposition of the insanity defense is still variable. About 33% of jurisdictions allow for it, others don't, but ultimately, according to this case, the judge has to determine, did they waive it intentionally, knowingly, and voluntarily? There's other things. So when we're talking about insanity defense, you're going to hear from different states. There's all kinds of different things, different nuances that kind of seem like insanity, and that's what I want to get into here. This is called the deific decree, not to be confused with Creed, my favorite band. And so the defendant commits an act. They knowing it is legally or morally wrong by societal standards, may be found legally insane if they genuinely believe that it was under a direct command from God. I mean, we all see patients who are psychotic and they think God's telling them to do this. I mean, who in here hasn't seen somebody like that? Not all states have this. It's across the nation. It varies. But it's considered an exception to the general understanding of insanity defense, and it has been adopted in jurisdictions like New York, Washington, or Colorado. I know maybe Dr. Perkins can speak more on that since he works up there sometimes. Critics say it ties to outdated views, it's inflexible, and it privileges certain delusions. There's also things like partial responsibility, diminished capacity, and mens rea, or the guilty mind. These are similar principles, and the prosecution must prove all elements of the alleged offense beyond a reasonable doubt, including the mental elements. And if the defense can defend against these mental elements, then they can be found guilty of the typically lesser charge, which does not include the mental elements. So it usually equates to a reduction of the offense or reduced criminal punishment. And it's been used in cases like Fisher v. United States. There's also something called the heat of passion. I don't know who reads those dragon books, but you know who you are. My wife reads them. I've heard about them. But the heat of passion. So it's used to reduce murder to manslaughter or other less serious offenses. And there's three elements that you have to prove. The act was committed under the influence of the heat of passion. A normal person would have probably acted similarly, and there was no time for the defendant to cool off. The heat of passion does not presuppose any kind of mental illness or defect. It can negate criminal intent because the act resulted from a sudden, I liked this word, incendiary provocation, which is different from premeditation, okay? So keep heat of passion in mind, and let's compare it to this one. It's called an extreme emotional disturbance. It's a broad, formalized defense. It can involve various mental disturbances. New York enacted this in 1967, and the defense must prove that when the act was committed, the person was under an extreme emotional distress, and it must be reasonable explanation or excuse for the circumstances. And it's considered to be that the defendant sustained a significant mental trauma. So contrary to the heat of passion, which happened right then, there's no cool down period, this extreme emotional disturbance, because it's considered trauma, it may bubble up in this person who was traumatized weeks, months, years after it. So there's the heat of passion, there's extreme emotional disturbance, and then we've all seen these things: alcohol, drugs, and criminal responsibility. You know, Doc, I wouldn't have done it, but I was doing meth, and then I killed her. I'm sorry. You know, but for the meth. So here is this strapping gentleman, Mr. Lord Chief Justice Matthew Hale, and he talked about dementia affectica, which is Latin. It stands for like intoxication. And he said, shall have no privilege by the voluntary contracted madness, but shall have the same judgment as if he were in his right senses. With two exceptions: involuntary or innocent intoxication. You go to the bar, this young strapping gentleman slips something in your drink, you didn't know it, and you do something. That would be involuntary or an innocent intoxication. Then there's also what's called settled insanity, which is long after you did maybe this mind-altering substance, there developed a mental illness. So there are some exceptions, but for most places, voluntary intoxication does not qualify as a mental disease or defect or insanity. I don't know of any. Maybe other people do, but I don't know of any. And this might pertain to a diminished capacity, or maybe at mitigation you could talk about it for sentencing purposes, but it's not an insanity defense. And it talks about the mens rea and specific intent and such. What about impulse control disorder? So pyromania, kleptomania, intermittent explosive disorder, pathological gambling. It's possible in some jurisdictions which use the irresistible impulse or that volitional prong, which we talked about earlier. I trained in Virginia, which actually is one of the few states that does have the irresistible impulse prong. It was rarely met. Doing insanities up there through fellowship, I never had anybody meet that standard, but it is there. And so it's like for pathological gambling, it really depends. In Connecticut, there's a case where it was allowed, and there was another case where it was disallowed. For intermittent explosive disorder in Maryland, it was allowed. In New York, it was allowed. But in a U.S. military case, it was not. So then there's automatism. So this gets into, we've talked about the mens rea or the guilty mind. There's also the actus rea, which is the guilty act. Was it voluntary? Was it done consciously? There was a case, People v. Kelly, 1973. The court reaffirmed the long-standing California principle that an act committed while unconscious is not criminal. And you might ask yourself, well, how can you commit a criminal act if you're unconscious? Think about sleepwalking, seizures, if you had some bad head trauma, anesthesia, you're coming back from anesthesia, or even severe hypoglycemia. And that it's called automatism. So we've talked about a lot. McNaughton, which is what is used most across the United States, We've talked about irresistible impulse, the model penal code, the Durham product test. Well, I'm a very visual person. Got to keep it simple for me to understand it. So let's move on to the map and look at it. So here's a picture. These states, Idaho, Kansas, Montana, Nevada, North Dakota, and Utah, they don't have an insanity defense. So if you go there and you kill a bunch of people and you want to claim insanity, you're toast. Now, some of the other states, this includes Mississippi, it's the dark gray color. 28 states, these use the complete loss of understanding or that cognitive prong. That's McNaughton. It's a strict McNaughton. Did they know the nature and quality of their act, or did they not know the wrongfulness? That's the legal wrongfulness, not the moral wrongfulness. Now, some states, so it's the checkered one, Arkansas, Illinois, Kentucky, Maryland, Oregon, Vermont, they have a broader interpretation, and this is basically the substantial impairment of the model penal code, the ALI, the American Law Institute. And substantial impairment, so right here they say, a person is not responsible for criminal conduct if at the time of such conduct as the result of mental disease or defect, he lacks substantial capacity, which is a more broad term, either to appreciate, there's a lot of wiggle room there, the criminality, they chose the legal term of criminality of his conduct. So that's those states. Now, there's some other states. This would be, I think that's the lines, the horizontal lines. And so, or actually, no, that's the dotted lines as well. They're still using the model penal code, but instead of using the word criminality like this one, they're using the word wrongfulness, which can get into a moral debate. And then there is the product test, or the Durham test. This is only used in New Hampshire. I think it was used in D.C. at one time, and I think they got rid of it. I think it's just New Hampshire.
And the U.S. Virgin Islands.
Thank you. So if you're ever in the U.S. Virgin Islands, like Dr. Gigliani goes to all the time, and you commit a crime, you might get away with it if it's the product. The product. It is a lot easier because the product of mental illness, you as a psychiatrist can get on the stand, and you've got a lot of freedom. You've got a lot of wiggle room. And then as far as, that's all pertains to the cognitive prong, the knowledge. We've talked about the volitional prong. Look at how many states got rid of the volitional prong, the black. All of those states say, we're not dealing with the irresistible impulse or the impulse that was just chosen to be ignored. So then there's the dark states, which are the three there, New Mexico, Ohio, and Virginia, where I trained. And that they do have the irresistible impulse. But even there, it was rare. I really never saw somebody meet that. And then there's the light gray, and these include, they include the volitional prong. As you can tell, it's not that many, and it's the model penal code, substantial impairment, which gives them a lot of wiggle room. And it says he lacks substantial capacity to conform his conduct to the requirements of the law. So, in all of this, why do we have so many? Why is it taking centuries to get to where we are? And it's because there's a lot of disagreement on two main things. One is the severity of the mental impairment, complete with McNaughton versus a substantial loss with the model penal code. So how severe does it have to be? That's been a debate. And whether the volitional prong component, irresistible impulse, should be included or not included. Those two factors have been what's really made this such a debate and variability across all the states. So as you can see, Here's just a picture. I like the picture because it makes it simpler for me. McNaughton, cognitive only. It's a complete loss. It's a narrow scope. It's all the way over here to the left. The model penal code is considered somewhat balanced. It's got a cognitive prong and the volitional prong. Not every state uses it. It's right here. And then the Durham, or the product test, way over here to the right, is very broad. You as a psychiatrist can get up there and say, yeah, I think it was the product of X, and just put the mental disease there. Again, repeated criminal behavior and antisocial behavior, antisocial personality are excluded, but you still have a lot of room, and it puts a lot of weight on your shoulders. So here's kind of a chart just saying what I've already said. I won't belabor that. And one other thing before we get into kind of some cases, some national cases, is guilty but mentally ill. So this is another option for dealing with patients who have mental disorders in the criminal system. It's basically saying a mental illness existed at the time of the crime but did not contribute to the act. So it's not an NGRI defense. And people who've been in our hospitals and get released, just because they have mental illness doesn't mean they were insane at the time that they did it. That's basically what this is getting to. And it allows for juries to recognize a defendant's mental illness without finding them NGRI. So now, to finish up, I've got two things I want to do last that are interesting. I just want to talk about some cases that have been across the nation, and you've probably heard of them, that involve the insanity defense. And then I've got a little trivia at the end. And please, to all my forensic people, chime in or add anything that you find important. So John Hinckley, 1981, he attempted to assassinate President Ronald Reagan. This sparked national outrage and led to a major reform in federal and state insanity defense. And it ultimately led to, he was found not guilty by reason of insanity, and he spent about 34 years psychiatrically hospitalized, and he was conditionally released in 2016.
So
yes, sir.
One of my supervisors at UNC was the only state's expert in Hinckley.
Wow.
Sally Johnson, and she was a brand new forensic psychiatrist, hella pregnant while she was working on this case.
Oh, no.
Killer, right?
Wow.
She was the only one, and because this was such a high-profile case, this army of defense lawyers and an army of forensic psychiatrists and psychologists came in and offered testimony and served as expert witnesses. And so she still thinks she's right. Actually, historically, she probably was right, even under the standard at the time. But it was much more political, and he just had a team that was unstoppable because everyone wanted their face on the TV and they wanted to be involved. And the defense had the money to do it, and so the state had a single person who was and she's brilliant, but it's really hard to overcome that sort of structure. So it's an interesting that turned the tide, this unfair, disproportionate dedication of resources to this guy. You guys know the delusion there. He had to kill President Reagan. So John Hinckley attempted to kill President Reagan because he wanted the affection of Jodie Foster. And he believed he could get her to be his girlfriend if he murdered President Reagan.
And by the way, while he was out, conditionally released, he was some of his privileges were revoked for a little while because he was going to the library and still Googling and researching Jodie Foster, which conditional release, he cannot do that. But now he's actually out completely, lives with his elderly mother, who's older than him, and he has a YouTube channel. He makes music, he has artwork, and all sorts of stuff. And he's complained because Secret Service agents continue to follow him, and that has made it very hard for him to find a job, he says.
Wow. Interesting. Wow. Wow. What was her name? Sally?
Sally Johnson.
Sally Johnson.
She doesn't like me, but okay.
Well, I mean, that's understandable.
I mean,
I didn't work very hard.
yeah. Okay, Andrea Yates. Now this one's just horrible to me, and it's just, she drowned her 5 kids in a bathtub. I just cannot fathom that, and it's just awful. But it highlights postpartum psychosis. One of the sickest patients I've ever seen was postpartum psychosis in Virginia, and it talked about and it highlights some of the flaws in the criminal justice system. She was initially convicted, but later found NGRI, and she remains inpatient at a psychiatric hospital in Texas in 2017 or 2007.
You talked about moral versus legal wrongfulness, right? So Mississippi isn't moral or legal wrongfulness. You guys know? It's legal wrongfulness. So if you have a woman who's experiencing this is relevant in high stakes. Because if you have a woman who's experiencing postpartum psychosis, it usually has to do with the world's coming to an end, and the only way she can save her innocent children is by killing them, right? So if you were to tap that mother who's about to drown her baby in the tub on the shoulder, and you said, "Is it wrong for you right now to kill this baby?" What would she say? No. Why? Mercy, right? But if you asked her if it were illegal to drown the baby, what would she say?
Probably yes.
So it's consequential, right? This distinction between moral and legal wrongfulness. If you're ever going to offer testimony, it's useful to know what standard your state falls under. So.
And I've seen an expert almost get excluded from testifying because they used the wrong standard in their evaluation. They used appreciate also, so they didn't know that it was know and not appreciate, and there is a difference. But because the judge excused, Dr. Van Winkle was with me, she observed my testimony, the judge excused the jury. And they had an extended voir dire where the judge was questioning the expert, and the judge said his decision was, "I'm going to let her testify because if I don't, you don't have any defense." But he's like, "But she did use the wrong standard."
Yeah.
Who
Ouch.
knows why she was initially convicted and then later found NGRI? It was.
Yep.
So Park Dietz, who I actually work with, he is who I do my private work with, he testified that there was a Law and Order episode that preceded her murdering the children. And so he testified that, because he's an expert for them, he does consulting work for them. He testified that she got the idea of this from Law and Order. And then the producer, Dick Wolf, told him, "No, we made that episode off of this case." It was straight off of the headlines and came out like a few weeks after the case. And so Park had to go to the court immediately and tell them, "I was wrong. This was wrong." And even though there was still a pretty good argument that she did not meet the NGRI standard in Texas, they decided that they did not want to have a whole nother three-ring circus, so they decided to find her NGRI on the second go-around.
And actually, most successful NGRI verdicts are a bench trial, where it's before the judge and they're just decided.
How many jury
agreed beforehand.
in Mississippi? How many jury NGRIs have there been? I don't even know if there's been two.
I don't know that many.
It's
I know there's
one,
been
maybe two.
I know one of our former patients definitely had a jury. All the ones I've testified at that were successful were bench trials. I know of George Carley was a jury. And Kunta Lewis was a jury, so two that I know of.
Wow. So.
And neither one of them were really NGRI, in my opinion, by the way.
Did you get to testify to that? Okay, we've got a few more minutes and I'll finish up. So, James Holmes, this one bothers me because I just feel I could see myself being in that Batman movie theater watching the premiere, and this guy comes in. So it raised the question about how courts assess mental illness in mass shootings. He was found guilty despite an insanity plea, and he received life in prison without parole. Lorena Bobbitt, she severed her husband's penis after alleged abuse. This was a media spectacle, and it became cultural flashpoint for domestic abuse and gender roles. She was acquitted by NGRI due to temporary insanity.
Which doesn't really exist.
Right. Maybe it was a heat of passion. Could it be a heat of passion, maybe? So Jeffrey Dahmer, serial killer and cannibal who murdered 17 men and boys. Defense claimed mental illness, but a jury rejected it and raised ethical questions about mental health and evil. He was found sane and guilty and sentenced to life in prison.
Where he was killed by another inmate.
I'll skip that one. Let's see. I just want to do the ones everybody knows. Anybody know this guy? Murdered John Lennon? Yeah. So he was diagnosed with schizophrenia, but insisted on responsibility, and the court accepted his plea. He pleaded guilty despite insanity considerations. He was sentenced to 20 years in life, and he remains in a New York State prison. This guy, Jared Loughner, he did a mass shooting in Tucson, Arizona, and injured Congresswoman Gabby Giffords. And this case raised major questions about forced medications and mental illness and politically motivated violence. Seems like that's frequent these days, becoming more common. And he was initially found incompetent, later medicated and found competent to plead guilty. He's serving 7 consecutive life sentences, following 140 years in prison. So. All right. Real quickly, these are just some stuff you might have on a test one day. What is the test for insanity in a criminal case? Is it the Dusky standard, at least here in Mississippi? Is it McNaughton's rule? Is it reasonable persons, or strict scrutiny? McNaughton. Easy one there. And then we didn't talk about this case, Fauci v. Louisiana, but I still think you can get it, and it's relevant to, especially here at Whitfield. What are the requirements to hold an insanity acquittee in a psychiatric hospital according to the holding in this? Is it mentally ill and dangerous, mentally ill and disabled, mentally ill and amnestic, or mentally ill and refusing treatment? Dangerous, yes. Mentally ill and dangerous, which Dr. Record, Dr. Perkins can tell us about a lot of guys over here at our nice forensic unit, I'm sure.
The point in Fucha was that this guy was super antisocial and also had a history of mental problems. So his mental problems get completely better, and then there's a conditional release hearing, and the psychiatrist testifies he's totally better. He's mean as hell, but totally better. The court wanted him to stay in the hospital, as they do, and so it went to the Louisiana Supreme Court, and the determination was made. Once you got to be both mentally ill and dangerous. If you're no longer mentally ill, right? So it's an interesting case, and I think it's useful when we're thinking about sort of civil commitment, dangerousness issues, and all of that.
Yeah, exactly. What is the issue that was considered in Friend Act? We talked about it earlier. I'll give it to you. It's criminal responsibility and such. So, anyways, these are my sources that I use. Highly recommend them. Applebaum and Guttal, Rosner and Scott. This is a good board review by Farrell that helps with questions, and this was an article I used where I got a lot of the pictures from. So, and then I got a lot of sources. But anyways, lots of sources. Any questions? Right. Okay. Well, thank you for your attention.